You said lawmakers passed some laws in Baton Rouge regarding domestic violence. We know Gwen's Law was one that was kind of put in after the death of Gwen Cox Sally, and we'll talk about that. What are some of the other laws that you watched as lawmakers pass? I know you were down there weekly, correct?
Absolutely. We were down there 2 or 3 days every week during the legislative session, Erin, because we were very concerned about any of the laws that would affect the criminal justice system and certainly to protect victims.
The domestic violence laws you were referring to a minute ago, what's now on the books?
Well, first of all, House Bill 1142, which is now Act 318, is referred to as Gwen's Law. That was brought by Representative Burrell, and I was there to testify with Representative Burrell at the Administration of Criminal Justice Committee. Obviously, what happened here and the estranged husband of Gwen Sally abducted her, drove her to Caddo Parish, killed her, and then killed himself. The estranged husband had been arrested on a previous incident and had bonded out of jail. He had posted bail, and as I recall, a substantial amount of bail. I think it was either $20,000, $30,000, $40,000, $50,000, but it was a substantial amount of bail. As cases go, but obviously it was not sufficient to hold him in jail. The trick here, Erin, is that you've got a United States constitutional right under the 8th Amendment to bail and under the Louisiana Constitution. So you've got to weigh the presumption of innocence and the right to bail with the right of the person, in this case the victim or potential victim, to be safe and the community to be safe. And that's a balancing that occurs every day at every courthouse in the United States.
What does this law now require?
This particular law now requires a hearing, a bail hearing, before bail on a felony charge can be set. But if the judge enters a uniform abuse prevention order, then that would also prevent the person legally from possessing a firearm. So what we're going to be facing in the criminal justice system is a situation where you've got someone who is charged with a felony such as aggravated battery or second-degree battery of a spouse, and you'd have to have a bail hearing. Well, at a bail hearing, you're going to have witnesses, you're going to have reports, so the officers are going to need to come in, the victim will need to come in, and the judge will have to make a decision.
What's the difference in this circumstance and what happened in the Michael Sally case? He had a bail hearing, right?
I don't know that he had a bail hearing. He may have.
Okay.
But I think in most cases, Erin, what happens is the judge is advised of the person that's in jail, is given a 72-hour affidavit, or 48-hour affidavit, I'm sorry, and reviews the quote facts, close quote, of the case, the notes made by the officer, would consider the criminal history, whether the person's on probation, parole, or has a history of violence, and set an amount of bail. And they do that by telephone routinely. Mm-hmm. So in most cases, I think in the past, these things have been done as a matter of those procedures, those type of procedures. But now, this particular law, Gwen's Law, will require a bail hearing if the person is charged with a felony on a household member.
A domestic violence, a household member. So it
household
could be
member or a dating partner.
Okay, so it could be a child, could be a spouse, could be a girlfriend.
Yes.
Okay.
Exactly. Other
laws that they passed or that they were working on this session?
Well, Representative Moreno, who also serves on the Administration of Criminal Justice Committee with Representative Burrell, had several bills. There's now a mandatory arrest of an abusing party who is in violation of a protective order, a mandatory arrest. So this is going to be a challenge to the law enforcement community when they come upon these situations. The
mandatory arrest.
Mandatory arrest.
So if she can show a protective order, or he, whoever's been battered, can show a protective order.
And a violation of that protective order.
Yes.
Then mandatory arrest.
Okay.
There's another bill also by Moreno, now Act 195, prohibiting possession of a firearm by one convicted of domestic abuse battery. And let's take a moment. You know, domestic violence is a term that's thrown around. Domestic abuse battery is a crime. Mm-hmm. Domestic violence is like a syndrome or just a description of a variety of events. But cruelty to juveniles is a crime. Domestic abuse battery is a crime. So a person who has been convicted of domestic abuse battery within the past 10 years may not lawfully possess a firearm.
Goes back then. So it goes back 10 years from ahead of now.
That's what the law says.
Wow.
That's what the law says.
How are you going to enforce that? Are you going to have to go through your cases and find out who's been convicted of this? And
Well, it's not ex post facto, so it'll be, just for the future.
if they ever come forward
That's correct. If they
for a
violate
case again.
That's correct.
Okay.